court, and then we give direction on those applications, and then E565. Those are the three matters which are before this court and in which the Honorable the Chief Justice has constituted this bench for hearing and determination. There are articles of constitution of this bench in the court. So the three matters before the court are E565, E015, E0113, and E014. Those are the files and petitions, applications before this court. And those are the applications on which this bench has given direction pursuant to this bench being duly constituted. So any other applications which we are talking about, we have not cited them. Maybe they are yet to reach us, but for the purposes of today's hearing, we have these three petitions or applications.
Your Lordship, we well guided, and perhaps also state for record that we also appear in E015 in protest. But for that, Your Lordship, kindly confirm that the number that is now registered in the matter that came from GACHAGUA is E015. And that is important, Your Lordship, because of the purposes of administrative transfers of files. Because what was at GACHAGUA, Your Lordship, was E015. Does it therefore mean that that file has not yet been integrated into the Nairobi files? And if so, then how do we appear to proceed before you, and how was the matter that we shall raise the issues? Just confirm on the question of the integration of that file in the Nairobi files, because the last file that we have should be 565 as at Friday. Are we dealing with the matter in GACHAGUA or in Nairobi?
Let me deal with that. Lord, for the purpose of A572 of 2024.
That file is not before us.
That's all I'm only saying. I have had the directions of the bench. The file is not before you. But I have instructions for the purpose of the one to take that petition was filed on 18th of October. The same day, the Kerugoya file were filed. All the directions in all these files that have been taken to a graveyard is that none of these files of ours are orders. The reason as to why Kerugoya files before the learned judges is purely because they have orders to stop the swearing in of the deputy president-elect. The CJ could not have selectively decided to have only one file before you, my lord. This is a trial of the judiciary. It is a trial that goes to the root cause of whether there is impartiality.
Mr.
Yes, my lord.
Mr. Omari.
Yes, my lord.
The file you are addressing us, we have said, is not before us. And the files which are before this court are the files in which this specific bench has been empaneled.
Thank you, my lord. Allow me to mourn. Because the questions I'm raising are very pertinent, that there are files selectively brought before you, but there are others.
Mr. Omari, we wouldn't know that because, as you understand, we only deal with matters in which we have been empaneled. We do not empanel ourselves.
Thank you very much. The empanelment authority has had me now done. Thank you.
Well, I had indicated these honorable court that there will be at least 3 clarifications.
Just a minute to something.
Yes, madam.
Now, I think we need to get something right. I want to clarify how these files are before this bench this morning. The 3 files which were filed in GACHAGUA, that is 13, 14, and 15 of 2024, had some interim conservatory orders issued by the court. Further to the issuance of those orders, the learned judge made further orders requesting the Honorable Chief Justice to empanel a bench. Those files were transmitted on the basis of that order to the Honorable Chief Justice's office on the 18th of October 2024. On that very day, the Honorable Deputy Chief Justice empaneled this bench to hear those matters. Thereafter, applications were filed online. I think you are all aware that they are operating online. Applications were filed online. When those applications were filed online, those are the ones which this bench gave directions for these matters to appear before us today. That is why we're here, and that is the trail, that is the paper trail as to why we're here this morning. So I reiterate the position taken by the presiding judge that we will not be comfortable dealing with any other file, even if it's related to this file, which we did not give directions for it to appear here today. So I think we can now proceed on the basis of that clarification.
Thank you, Judge.
My lord,
Just a minute, please.
Perhaps just to add that it's the numerous other petitions that are coming up.
yes, my lord, I believe now I can be able to make the clarifications. We are starting with the immediate background that we need to make these clarifications, and we take into account.
Let us finish with quorum first. There's a quorum in E013, which was consolidated in GACHAGUA with E014. Just take quorum on that file.
Your Lordship, is terribly something wrong. And I believe it is important for us to put things into proper perspective. Because when you call the matters E13 was not part of what was called. I've not heard it perhaps to be called. Your Lordship, in E015, there has never been a consolidation. To the best of my knowledge,
What are you talking about consolidation? Nobody has talked about any consolidation. These files have not been consolidated. I think that is the next process we'll be going into. Nobody has talked about any consolidation. If you look at the record, you will find that the directions for today's hearing are given specifically on each and every file. There was no consolidation of any matter. No matter has been consolidated. So let us not dwell on things which really are not before the court. Now matter has been consolidated. Let us proceed from there. If you want to apply for any files to be consolidated, that is okay. As we speak now, there is no consolidation. The direction from this court were very specific on 3 different files.
my lords, I'm well guided, but when Justice Murima was giving the clarification, I never heard him clarify whether the Kirogoya file has been integrated into the Nairobi system. Because we cannot be dealing with a file that is reading Kirogoya. Because of course, if there is no integration, Your Lordship, then there is a rat that is made.
My Lord, may I say something?
Let me answer you. You said that record speak for himself. And for record, matters which came from Karagoya came with their own record. And the record states here that the matter herein is consolidated with petition E014 of 2024 and the same to be delivered in the Chief Justice for empanelment of bench in terms of the ruling in petition E014 of 2024, a copy of which shall be placed on this file. So your own matter coming from Karagoya was already consolidated. Those proceedings which took place in Karagoya consolidated these 2 files. So let that not be an issue here, please. On the directions issues on 11 by Judge Richard Mongo, these were the directions. The petitioner in E014-2024 to serve their amended petition on all parties. Similarly, the petitioner in E013-2024 to serve their petition on all parties. Respondents to the petition to file their responses by noon of 17th of October 2024. Given that the files are being routed to the Chief Justice forthwith, the parties' response to the amended petition and petition E013 of 2024 may be filed in Karagoya under the Karagoya case tracking system online, whereupon they shall be forwarded to Nairobi. So these proceedings took place in Karagoya. So this court has not consolidated any matter. Petition number E014 and petition number E013 are hereby consolidated. The parties who appeared before the Karagoya court were given those orders. Those were your orders.
And with your permission, Presiding Judge, the reason why Nairobi has not opened another file to put together all the files from Karagoya is this. Going by the orders which were issued by Karagoya court, there was a specific order that because of the transmission, parties will still file their documents under the Karagoya CTS, that is the court tracking system. We had to hold on to that so that not to disadvantage any of the parties until we appear today. Those are some of the things we will deal with here and make orders to the Honorable Deputy Registrar to formalize that. So there should be no cause for alarm. We will put everything into its place.
I presume now we may now raise the issues that we want to raise, particularly arising from the issues in Karagoya. And I do
We
not
will then
know.
proceed and take quorum on it. They were consolidated, so we don't take further quorum on this matter.
Attorney General, I don't know, I have indicated to the court, I need to raise some clarification.
Section 7 of the
You had already asserted. It doesn't override my right to represent my client. Can she then say her piece? I say mine.
Now, which matter are we now dealing with?
We have 0115. We have 0115.
My Lord, I wanted to say that
Yes.
the only matter they were filed before impeachment and they have been considered to be
I think they do.
we have E15
E15 has to.
conservative, but E13 and E14, although from Kerugoya, they were filed before impeachment and they have no conservative members.
I hope I have dealt with her without further appearances. My Lord,
Which of the matters?
My Lord, I'm leading the number of advocates in this matter from Kirinyaga, E015.
Kerugoya 15.
Yes, Kerugoya 15.
Yes.
Yes. My Lord, the clarification that I seek to raise emanates against this general background. The first one, my Lord, is that there was a sitting on Saturday, which the court has since explained how that sitting occurred. With regard to that sitting, my client wrote a letter to the Honorable the Chief Justice, which has been placed on record in an affidavit in an application before you, that protesting, amongst other things, that the practice in which a Saturday sitting would be convened for purposes of hearing the executive and organs of government that have violated fundamental rights is a practice that is prohibited under the 2010 Constitution. That letter is on the record. We do not trust that the Honorable the Chief Justice could actually do that because she knows the history about what used to happen. But we now learn, Your Lordships, that you are convened by the Honorable Lady Justice William, the Deputy Chief Justice. Lady, my Lord, arising from that are one, a legal issue and a matter of Article 150. My Lord, under the law, and we do this every day, I practice public law every day. Arising from that issues of the communication, speaking for 015, we expected that the general procedure would be, and that is what the orders implies, and required us to come on Thursday this week, that when the Chief Justice appoints a bench, she will do it in writing as required under Article 47 of the Constitution. We would be given the number of those judges and the day that they will be sitting.